I knew something was wrong. The second I stepped into the lobby of Valiance Financial and the receptionist refused to meet my eyes. Her pupils were glued to a minor chip in the Italian marble desk, avoiding any direct contact. I had not even placed my leather briefcase down when an Outlook alert chimed on my phone. The subject line read in all capital letters, "Urgent Performance Review, 9:15 in the morning, Conference Room 4C." No body text, no signature, no context. It was a classic corporate ambush, the kind designed to keep you off balance before they drop the guillotine. Let me set the stage. I am George Vance, 54 years old, and I have spent over 3 decades navigating the sharp corners of corporate finance. I had just wrapped up 12 consecutive quarters of record-breaking growth for the asset management division. 3 weeks ago, I finalized the Hastings account, which was projected to bring $28 million in revenue to our firm over the next 3 years. I built that entire deal from a simple pen sketch on a cocktail napkin during a turbulent flight from Dallas, working through long nights, endless client revisions, and intense negotiations to secure their trust. Yet, here I was, receiving a last-minute summons like a junior associate who had been caught stealing lunch from the break room refrigerator. When you survive in this industry as long as I have, you develop a keen instinct for corporate politics. You feel a cold warning in your neck when the corporate vulture starts circling your office. Olivia Thorne, the managing director, had her office door cracked open when I walked past. She was speaking in that low, hushed tone of mock sympathy she reserves for firing interns. It was the same tone she used last winter when she informed our senior accountant that his position had evolved beyond his current capabilities. That is corporate code for replacing a seasoned veteran with a 22-year-old whose father sits on the audit committee. Olivia represents the modern breed of executive, all public relations, superficial metrics, and complete lack of actual industry knowledge. I took the longest route possible to Conference Room 4. It was not out of anxiety, but pure strategy. I needed to gauge the atmosphere, look at who was suddenly preoccupied with their monitors, and see who was actively avoiding eye contact. Several managers turned away as I passed. A director I had mentored for 5 years literally stepped into the copy room to avoid speaking to me. That was the final confirmation I needed. The company was about to dump me, and they wanted to do it quietly. Before heading to the meeting, I stepped into my private office and unlocked the bottom drawer of my desk. I pulled out my original executive employment agreement. It was an 8-page document, but the most important part lay in the 3 pages of amendments I had renegotiated during the 4th quarter of the previous year. I flipped to page 5, tracing my finger down to clause 11C. It was still there, clear and initialed by Olivia Thorne, CEO Julian Cross, and myself. It was my shield, my financial kill switch, and my absolute insurance policy against the exact type of backstabbing maneuver I was about to face. They believed they could discard me once the Hastings account was finalized, but they had not read the contract. I folded the document, placed it inside my leather portfolio, adjusted my tie in the mirror, and walked out. Inside Conference Room 4, the blinds were drawn. Olivia Thorne sat at the end of the mahogany table, flanked by 2 human resources representatives who looked as though they had just swallowed thumbtacks. There were no laptops, no cups of water, and no folders. There was only a single sheet of paper resting in front of Olivia. "George, thank you for coming on such short notice," Olivia said, her voice dripping with artificial warmth. "Of course, Olivia. I always make time for the leadership team," I replied, remaining standing. She gestured toward the empty leather chair opposite her, but I declined to sit. She cleared her throat, preparing to deliver the script she had undoubtedly practiced in front of her mirror. "George, we are restructuring the asset management division, and unfortunately, your position is being eliminated, effective immediately. This decision is final and has been approved by our chief executive officer." Julian Cross could not even be bothered to show his face. I nodded slowly, showing no anger, no panic, and no sadness. "Understood," I said simply. Olivia blinked in surprise. She had likely expected a defensive argument, a plea for my job, or an emotional outburst. She did not know me at all. "We will require your security badge and company phone," she added. I placed my security badge and company phone on the table, smoothed my jacket, smiled politely at Olivia, and turned toward the door with absolute composure. Olivia and Julian believed they were saving Valiance Financial a $4 million equity bonus by terminating me today. What they failed to realize was that firing me exactly 23 hours before my equity was scheduled to vest did not save them a penny. It triggered Clause 11C. By rushing to get rid of me before tomorrow, they had just doubled their liability. They would learn the cost of their arrogance soon enough. I walked out of the conference room with my portfolio in hand, ready for the next phase. Instead of heading down to the parking garage, I stepped into the executive elevator and pressed the button for the 45th floor, which housed our legal and compliance teams. The air up there always smelled of warm copier toner, stale coffee, and laminated regulatory compliance manuals that nobody ever opened until they received a federal subpoena. I passed the mahogany-framed portraits of our founding partners and walked straight toward the back corner cubicles. That was where the real intellectual work of the firm occurred, far away from the corner offices. I was looking for Devin Patel, an assistant corporate counsel. Devin was a brilliant young attorney who had spent 3 years under my mentorship. He was the only one in that department who still retained a sense of professional integrity, having not yet been fully consumed by corporate survival instincts. He knew the inner workings of our compliance databases and was the perfect channel to deliver the packet. Devin looked up from his dual monitors as I approached, his eyes widening slightly as he noticed the leather portfolio under my arm. "George," he said, keeping his voice low. "I heard rumors in the elevator. Did they actually go through with it?" "They did," I replied, stepping into his workspace and closing the door behind me. Effective immediately. Olivia Thorne handled the execution, acting on direct authorization from Julian Cross. They cited restructuring, but offered no cause, no severance packages, and absolutely no transitional support. Devin shook his head, a mixture of disbelief and anger crossing his face. "That is absurd. You built the entire asset pipeline they are currently leveraging. What are you going to do?" I opened my leather portfolio and pulled out a duplicate copy of my renegotiated employment contract. I flipped to page 5, pointing to the bottom paragraph. "I want you to read Clause 11C, paragraph 3, subsection A," I said quietly. Devin leaned forward, squinting as he read the lines. His eyes moved rapidly across the text, then slowed down significantly as he reread the section a second time. His face lost its color and his posture went rigid. He looked up at me, his mouth slightly open. "George, is this what I think it is? If they terminate my employment without documented cause within 24 hours of my scheduled equity vesting date, they do not void the bonus," I explained. "The contract explicitly dictates that such a termination triggers an immediate, non-negotiable acceleration of all remaining equity, payable at current market value, plus a penalty multiplier of 2 times the original bonus amount, along with full base salary compensation for the remaining term." Devin let out a soft, sharp whistle. "That means instead of avoiding a $4 million payout, they have just activated a contract that obligates them to pay you $8 million, plus damages and fees." "Precisely," I said, and they signed it. Olivia Thorne initialed the implementation memo, and Julian Cross signed the final contract amendment last December. I have the digital files, the DocuSign metadata, the IP tracking records, and the notarized hard copies. They cannot claim they did not see it. They thought they could short-circuit your compensation by executing the termination. "One day before the deadline," Devin whispered, looking at the contract as if it were a live explosive. "They thought termination voids all future obligations. They did not realize that the termination itself was the very trigger that activated the double payout. This is going to create absolute panic in the executive suite." "I am not looking for a messy public battle, Devin," I said. "I am here for contract enforcement. I want you to take this packet directly to the General Counsel. Let them examine the signatures and the timestamps. I would prefer the realization of their error to spread from compliance outward, rather than through a public lawsuit." Devin nodded, his expression turning serious as he scanned the pages into his computer. "I will take this to the lead counsel immediately. They need to understand the scale of the liability they have just created." After leaving Devin, I made a brief stop at the compliance desk to see Clara Jenkins. our chief compliance officer. Clara was a meticulous researcher who had spent 15 years tracking corporate assets and policy violations. She was the one who kept the firm database running. I handed her a second copy of my contract, along with the digital metadata files stored on an encrypted drive. Clara, I need this logged into the internal repository, I said. I want a permanent, time-stamped record that compliance received these contract annotations within 1 hour of my exit. Clara took the folder, her eyes scanning the bolded sections of Clause 11C. Her eyebrows rose. Fired 23 hours before vesting? Did Julian actually sign off on this? He did, I replied. He laughed and told me, only attorneys read the fine print when he initialed it. Clara shook her head, a grim smile appearing on her face. Then he is about to learn that the fine print is the only thing that matters. I will log this immediately. Thank you, Clara, I said. I turned and walked toward the elevators. The halls were quiet now, the news of my departure having likely spread through internal messages. But I was not leaving the building defeated. I was leaving it with a perfectly engineered contract, and the executives had just tripped the wire. Within 2 hours of my departure, the executive wing of Valiance Financial descended into a state of quiet panic. Olivia Thorne marched into the Human Resources conference room, her face flushed with stress. She slammed her thin laptop onto the glass table and turned to Nancy, the Director of Employee Relations. Nancy, I need George Vance's entire disciplinary history and performance record on my desk right now, Olivia ordered, her voice trembling slightly. We need to document a clear, retroactively justified cause for his termination. We must find some policy violation or performance failure. Nancy stared at the screen, her fingers clicking hesitantly on the keyboard as she accessed the secure employee database. Olivia, there is absolutely nothing here, Nancy replied. He has never received a verbal warning, a written coaching note, or a single negative remark in his annual evaluations. His performance file is entirely pristine. For 12 consecutive quarters, he exceeded every financial target we set. He has no late timesheets, no unapproved travel expenses, and no client complaints. In fact, every single client survey returned for his department in the last 3 years gave him a perfect score of 10 out of 10. He is the most productive executive in the firm. There must be something, Olivia insisted, pacing back and forth across the room. Check his expense reports, his email logs, or his client communications. We cannot have an executive of his level leaving without a documented paper trail. If we do not have a cause, we are in deep trouble. Nancy shook her head. We cannot fabricate a performance issue, Olivia. That would expose the firm to immediate wrongful termination claims. His file is closed, and he was terminated under a standard restructuring program. Before Olivia could respond, the heavy glass door of the conference room swung open. Diana Sinclair, the lead general counsel for Valiance Financial, stepped inside. She was holding a red folder containing the contract Devin Patel had escalated to her desk. Her face was pale, and her jaw was set in a rigid line. Olivia, we have a catastrophic problem, Diana said, closing the door and locking it. Olivia sighed, attempting to downplay the situation. Diana, if this is about George's termination, it is already finalized. He accepted the news calmly and left the premises. It was a standard restructuring decision to manage headcount costs. Headcount costs? Diana repeated, her voice dripping with sharp sarcasm as she opened the red folder. Did you or Julian Cross bother to consult the legal department before executing this termination? Olivia frowned. We did not need to consult them. Julian authorized the restructuring. Firing him today, exactly 1 day before his scheduled vesting, saves the company a $4 million equity bonus. It is a simple financial calculation. Diana dropped the folder onto the table, the papers sliding across the glass. It is a simple calculation that is going to cost this firm double, Diana snapped. George Vance did not just accept his termination. He handed his contract to compliance, and Devin Patel within 45 minutes of leaving. Olivia looked confused. What does that statement mean? His termination voids his future equity. He was not employed on the date of vesting. Diana pointed to page 5 of the document. Read Clause 11C, Olivia. You initialed this amendment yourself last December. The clause explicitly states that if George is terminated without documented cause within 24 hours of any scheduled vesting event, the firm is obligated to accelerate all remaining equity payouts at current market value. Furthermore, the termination triggers a penalty multiplier of 2 times the bonus amount. Olivia stared at the contract, her eyes widening in horror as she read the precise legal language. "This cannot be right," she whispered. "We were trying to prevent the payout." "You did not prevent it," Diana said, leaning over the table. "You activated it. By firing him today instead of letting him vest tomorrow, you converted a $4 million obligation into an $8 million liability. And because there is no documented cause in his HR file, we have zero legal defense. We have literally handed him an airtight breach of contract claim on a silver platter." At that moment, the door opened again, and Julian Cross, the chief executive officer, entered. He looked relaxed, a smug smile on his face. "What is the emergency, ladies? I hear George Vance has left the building." "Yes, Julian, he left," Diana said, turning to him. "And he took $8 million of our capital with him." Julian laughed, waving his hand dismissively. "Don't be dramatic, Diana. His contract says he must be an active employee on the vesting date to receive the bonus. We fired him 23 hours early. The bonus is void." Diana walked over to the digital monitor on the wall, plugged in her drive, and projected the contract onto the screen. She zoomed in on the signature lines at the bottom of page 5. "Julian, you signed this amendment yourself during the fourth quarter board meeting. Clause 11C is an accelerated payout provision designed specifically to protect George from bad faith terminations. It overrides the active employee requirement if the termination occurs within the 24-hour window before vesting." Julian's smile vanished. His face went stiff, and he stared at the screen as if the letters were written in a foreign language. "Who approved this clause?" he demanded. "You did, Julian," Diana said, "and so did Olivia. It is initialed on every page." The conference room fell into a dead silence, the gravity of the mistake finally settling over the executives. While the executive wing was descending into chaos, I was sitting at a quiet corner table in a small cafe 4 blocks away from the Valiant's financial headquarters. I ordered a black coffee and opened my personal tablet, pulling up the live status of the company internal system. Thanks to Devin Patel and Clara Jenkins, I could see that the legal department had already flagged my file, freezing my user profile rather than deleting it. I sat in the warmth of the afternoon sun, watching the steam rise from my cup. I knew the exact layout of the battlefield, and I knew the executives were completely unprepared for what was coming. At exactly 10:30 in the morning, my phone began to vibrate. The caller identification showed the private line of Richard Cole, the chairman of the Valiant's Financial Board of Directors. Richard was a conservative, risk-averse executive who represented our largest institutional shareholders. He cared about stock stability and avoiding public scandals above all else. I let the phone ring 3 times before sliding the screen to answer. "George Vance," I said calmly. "George, it is Richard," the voice on the other end replied. He sounded exhausted, the usual corporate polish replaced by a tone of controlled panic. "I have just come out of an emergency session with Diana Sinclair. We need to talk about Clause 11C. "Good morning, Richard," I replied. "I am always happy to speak with the board. I assume Diana has completed her review of my termination file and verified the contract annotations I submitted." "She has," Richard sighed, a long, heavy pause filling the line. "George, this situation is incredibly messy. Julian Cross and Olivia Thorne acted without board consultation or approval. They were trying to protect the company quarterly cash flow and prevent a large bonus payout. I want to offer you a fair resolution. We can put together a severance package of $4 million, representing your original bonus, with a standard non-disclosure agreement. We can put this behind us quietly and maintain our good relationship." I took a slow sip of my coffee, looking out the window at the heavy city traffic. "Richard, I appreciate the call, but that offer is completely unacceptable. We are far past the stage of a standard severance negotiation. You cannot offer me my own money to cover up executive misconduct. George, $4 million is what you would have received tomorrow anyway," Richard argued, his voice rising slightly in frustration. "There is no need to make this a public battle that damages the firm reputation." We have been partners for years, Richard. Let us look at this from a strict legal perspective, I said, keeping my tone measured, cold, and professional. Under Delaware corporate law, Julian and Olivia owe strict fiduciary duties of care and loyalty to the corporation and its shareholders. By executing a bad faith termination solely to avoid a contractually obligated payout, they did not just make a poor management decision. They knowingly triggered an accelerated liability that doubled the firm financial obligation, going from $4 million to $8 million. In the eyes of Delaware courts, this constitutes a clear waste of corporate assets. They acted in bad faith, and I have the time-stamped metadata proving they were fully aware of the clause when they signed it. Richard remained silent, but I could hear his heavy breathing on the line. Furthermore, I continued, my contract explicitly waives the requirement for mandatory arbitration if the firm acts in demonstrable bad faith. I have the sole discretion to file a public breach of contract lawsuit in federal court. If I file that complaint, the details of Julian's self-dealing, Olivia's failure to perform due diligence, and the board's lack of oversight will become public record. That would cause massive reputational damage and likely trigger a shareholder derivative suit against the board for breach of fiduciary duty. You would be personally exposed, Richard. George, you would not want to burn those bridges and ruin your standing in this industry, Richard said, though the threat was hollow and he knew it. Richard, I did not burn the bridge, I replied. Julian and Olivia poured the gasoline, and you let them hold the match. I am simply enforcing the terms of a contract that the board approved. If you want a resolution, it will require a full enforcement of Clause 11C. That means the accelerated bonus, the multiplier, and my remaining base salary. Nothing less. Richard took a deep breath. George, $8 million is a massive hit to our asset management reserves. The board will have to justify this expenditure to the shareholders. Then I suggest you justify it by holding the individuals who authorized the breach personally accountable, I said. Julian and Olivia created this liability through their own negligence. Under Delaware law, they can be held personally liable to the corporation for breach of fiduciary duty. If the board does not act to protect the corporate treasury, the shareholders certainly will. I will give you until 5 o'clock this afternoon to confirm compliance with the contract terms. Let me call you back, George, Richard said quietly. Take your time, Richard, I replied. I am not going anywhere. I disconnected the call and leaned back in my chair. I had given Richard the legal framework he needed to save the board while sacrificing the CEO and the managing director. It was a simple corporate math problem, and Richard was a numbers man. He would choose the cheaper option. By 4 o'clock that afternoon, the board decision was made. I was standing on the balcony of my penthouse apartment, watching the sunset cast long shadows over the skyline. A single email notification arrived on my personal tablet, containing the finalized settlement paperwork from the external legal counsel of the Valiance Financial Board. The terms were clear, precise, and entirely in my favor. The board had approved a total payout of $6,586,250, representing my accelerated equity, the penalty multiplier, and the remainder of my annual contract base. The transfer was set to clear within 5 business days, direct to my primary brokerage account. The attached agreement required my signature, but it did not contain any restrictive non-disclosure provisions regarding my career history. The board was too terrified of the potential Delaware law implications and shareholder backlash to push for further concessions. They wanted this document signed and filed before the market opened, hoping to bury the transaction deep within the compliance reports. I logged into my personal wealth account and watched the wire transfer settle from the firm corporate reserves. Seeing the final balance update was not just a victory of numbers. It was the ultimate confirmation of a strategic plan executed without error. I immediately allocated the funds into secure treasury bonds, securing my financial freedom. The internal purge at Valiance Financial was swift and absolute. Olivia Thorne was dismissed from her position before the markets opened the following morning. The official announcement was a brief, 2-sentence email stating she had resigned to pursue personal interests. But everyone in the building knew she was escorted out by security. Her reputation in our Dallas financial circles was completely shattered. When she tried to contact me later that week for a professional reference, hoping to salvage a role at a smaller boutique investment fund, I silently deleted her message without a second thought. She had spent years prioritizing optics over substance, and now the consequences had caught up with her career. As for Julian Cross, the board stripped him of his executive authority. They could not fire him immediately without triggering his own golden parachute, so they chose a far more humiliating path. They demoted him to the newly created role of Internal Alignment Liaison, an exiled position with no staff, no budget, and an office located in the basement near the servers. He went from running a major investment firm to monitoring internal network efficiency metrics, a corporate ghost in a windowless room. The executive dining room privileges were revoked, and his name was quietly removed from the directory. The board was sending a clear, brutal signal to the rest of the leadership team. Arrogance and lack of diligence would no longer be tolerated or subsidized by the firm capital. I did not return any of the frantic voicemail messages that followed. I ignored the calls from former colleagues who wanted to dissect the boardroom drama, and I ignored the messages from headhunters trying to lure me back into the traditional corporate structure. I was finished with their games. The corporate ladder is only useful if you want to climb, but once you understand the mechanics of the structure, you do not need to climb. You simply build your own. Instead, I spent the following week in meetings with the founders of Westridge Capital, a private equity firm that had been quietly outperforming Valiance Financial in several key sectors. We met in a quiet penthouse office overlooking the lake, far away from the noisy trading floors. They were in the process of raising a $200 million fund focused on mid-market industrial acquisitions, and they wanted me to lead the strategy. They did not want to hire me as an employee. They offered me a senior managing partner role with an immediate equity stake and absolute veto power over investment decisions. They wanted my strategic vision, my client relationships, and my reputation for precision. They knew how I had handled Valiance Financial and respected the cold intelligence of my maneuver. At Westridge Capital, I would not be subject to the whims of incompetent executives who failed to read the contracts they signed. I would be writing the rules from the start, building a legacy based on real value rather than executive vanity. On my last evening in the city, I sat in a high-end restaurant overlooking the skyline. I pulled out my phone, pulled up the contact for the Valiance Financial Board secretaries, and sent a single text message. Clause 11C, line 22. Line 22 was the final sentence of the amendment I had drafted 3 years ago. It stated that failure to honor the terms herein shall constitute a systemic breach of loyalty, subject to personal liability and public disclosure. It was the warning I had left in plain sight, initialed by Julian and Olivia during their rush to close the fourth quarter books. They had ignored it, believing their corporate titles made them immune to the consequences of their own ignorance. I took a slow sip of my drink, feeling a deep sense of professional satisfaction. I had not burned the bridge behind me. I had simply walked across it, taken the keys, and charged them rent for the wreckage they left behind. I was 54 years old, entirely financially independent, and about to start the most profitable and rewarding chapter of my career. The game was far from over. I had simply changed the board.